A general power of attorney is a document where you, the principal, name another person known as your agent to make decisions about your income, financial affairs, property, and other general matters. You can name one or more persons as your agent, but it's generally a good idea to name one person to serve as primary agent and then one or more individuals to serve as your backup or successor agents. And your agent should always be somebody you trust. Iowa law says that your general power of attorney always takes effect right away when you sign it, unless the document states otherwise. So for example, I might sign a power of attorney document today while I'm legally competent that says something like, my power of attorney doesn't take effect today, but it takes effect at some point in the future if my doctor decides that I'm unable to manage my financial affairs because I'm too ill to do so. Iowa law lists a wide range of powers that you can give to your agent under your general power of attorney, and you get to choose what those powers are. Those powers can include things like writing checks out of my checking account to pay my bills, filing my tax returns and paying my taxes for me, and managing my financial accounts. You can even include language that allows your financial power of attorney to sell your real estate if you want to, but that's certainly not required. Your agent has certain duties under Iowa law. They always have to act in good faith, and they can't use your money for themselves. Your power of attorney isn't allowed to be paid for acting as your agent unless your power of attorney document specifically says otherwise. Your power of attorney needs to provide an accounting upon request to certain individuals, and they're a fiduciary, which means that they always have to keep your best interest at the forefront whenever they're making decisions for you. In order to be valid, your general power of attorney must be notarized, and the notary shouldn't be anyone who's named in the document as your agent. You can revoke your general power of attorney at any time as long as you have legal capacity to do so, and you should always let your agent know that you've revoked the general power of attorney. It's important to have a general power of attorney because it allows you to name a financial decision maker who can step in the event you should become incapacitated. So I know that if I sign a power of attorney today and I become ill in the future, nobody will have to go and appoint a conservator for me in the probate court to step in and make decisions for me. Instead, I get to choose who my decision maker is going to be, and that way I have a lot more control over the process, and it's a lot less expensive and complicated than going through the probate court to appoint a decision maker if I should ever need one in the future.